Okay, welcome to Chapter 14, just one to go here. This is being recorded for Wake Tech, Court Evidence and Procedure, Courtroom Evidence and Procedure. We are covering Criminal Procedure, the 10th edition of that text by Joel Samara, S-A-M-A-H-A. This is published by Cengage Learning Company, and these slides are my own creation based off the text there for your edification and use, of course, in the class and out. This point of the course, we are finished with the precursor, that is the crime, the evidence, general rules about it, then its use when you're gathering sufficient evidence for arrest, and then the precursors to the trial, the pre-trial we talked about, and then the last chapter we talked about trial. This chapter we're going to talk about what happens afterwards and the use of evidence then. And you know, for people outside the field, it's kind of a curious question, I guess, because why do we need evidence after a conviction? I mean, we use the evidence to convict someone. Well, I think that's a fair question, but this really has to do with sentencing. It also has to do with most of the cases we've covered, because the cases that I've referred to, whether it's the Alford case that I talked about in the last chapter, are appellate cases, which means there was a conviction, and typically after the conviction the defendant has appealed. Now, it's possible that he appealed one at a circuit or at a Court of Appeals, and then it was appealed again by the state. But basically we can think about, well, how is evidence used then? And then we've got this term at the introduction of this chapter, habeas corpus, which is a good Latin word, and we'll figure out what that is as we go on through. Okay, so the first thing to kind of think about, and this is a very curious verses, the crime versus the criminal. The question is, if you're going to sentence someone to prison, are you going to focus on the individual, the criminal, or are you going to focus on his crime? And I think instinctively people tend to say, well, of course we're going to focus on the crime. And then I say, well, what about if it is a 10-year-old, a 5-year-old, a 50-year-old? What if it's a veteran or a handicapped person or an abused wife or an abused husband? So, then you're focusing on the criminal who might have committed this crime. So there's kind of two opposing points here. Determinate sentencing. Now, determinate sentencing, the legislature decides, here's your sentence. And this is really the way America criminal justice has been going the last 40 years. Back in the early 80s, we had indeterminate sentences. So you could have someone convicted of a crime that might get 1 year, and another person convicted of the same crime who might get 10 years. And people thought this was unfair. They thought judges were biased, so they said, well, let's just establish a universal standard. I think what people tended to forget is you're not getting rid of discretion there. You're not getting rid of these types of moral judgments. You're just moving to the legislature. But in determinate sentencing, you are focusing on the crime. The punishment is not individually structured, it's on the crime itself. And we're not as interested in mercy. Now, indeterminate sentencing, there it's up to the judge. The judge has a big, long leeway. He's got a lot of decisions that he can make to expand or contract the sentence. And the focus is on what is the best punishment for the criminal. It can be harsher if the judge says, well, this criminal is particularly bad, or it can be more lenient if they believe this criminal is particularly good. So, take that example I used, the beat husband or the beat wife. Suppose you have a spouse who is in an abusive situation, and that spouse waits for their significant other to go to sleep so that they do not represent an immediate physical threat. At that point, they kill the spouse. And I don't care if before that the wife beater or the husband beater had broken the battered spouse's nose or had raped them or assaulted them. When they are sleeping, they are completely defenseless. So when you kill them, you do not have the kind of, well, this guy was a threat to me or this woman was a threat to me. So arguably that's first-degree murder. If you focus on determinate sentencing, that's first-degree murder, unless you want to build in some special exception, which really makes your determinate sentencing kind of go out the window, because now you're going to start carving out exceptions. Well, in the past, we left this up to the judge. We used to say, okay, was this a wife beater, or was this just someone who broke in to commit a rape and an assault? The wife beater gets punished one way, the wife that is beaten gets punished another, and the criminal who breaks in to rape gets punished a third way. From defendant to offender. First of all, we're changing words here, obviously. The defendant has not been convicted of anything. But when the gavel comes down, after the jury says guilty, you are now an offender. And one of the magic things that kind of happens there is your presumption of innocence disappears. So that when you are appealing, because now we're in the appellate world, we're no longer in the trial world. When you're appealing, there's no presumption of innocence. You can't say, well, this guy who's appealing his conviction is presumed innocent. No, he was convicted. In fact, he's pretty much presumed guilty. And one of the things we also can do is we can look at more evidence, more things, if we're trying to determine punishment as opposed to guilt. One of the things that can happen is offenders lose rights during sentencing or appeal. They lose access to certain things they have when they were merely defenders, including restrictions on the right of habeas corpus. Now, habeas corpus is, and I'm going to tease this a little bit more, but it's the great writ, as it's called. It's really the right to produce the defendant in many ways. So we're interested really in kind of three post-conviction proceedings, and one of those is going to be habeas corpus or collateral attack. So here they are. Sentencing, you've been convicted, let's see what sentence you get. Appeal, you've been convicted, you've been sentenced, you don't like it. And then this collateral attack, this habeas corpus. So we'll take each of those in some detail, but first, as you know, any good liberal arts course would do, we got to give you a little history of it. Fixed sentences dominated the law pretty much from the birth of the modern law, and I would say the modern law comes into existence at the end of the Middle Ages, beginning of the Renaissance, say 1600s, to roughly the late 1800s, to roughly 1899. Okay? Penalties did tend to be more moderate than we think in some ways. Now, certain crimes, of course, were punishable by death that we'd never punish today, but even capital offenses, in a lot of instances, didn't carry the death penalty. In the 20th century, we shifted to indeterminate sentences. We gave more power to the judges, I think in part because we began to develop a group of people that were very well educated, the judges. We'd always had that, but we had a larger group. And we now trusted them. And by 1922, this is how fast it happened, all but 4 states in the United States had gone to indeterminate sentencing. They left it up to the judge. Now, the judge would often have guidelines between 1 year and 10 years, but they'd let the judge say 10 or 1. In the 1970s, this began to change, particularly the late 70s. One of the things that happened in the 1970s really was the publishing of a paper called What Works, strangely enough. And it really kind of galvanized, even inside the criminal justice field, the idea that rehabilitation was a failure. And indeterminate sentencing was also prejudicial and discriminatory. We began to see lots and lots of cases where minorities were treated far more harshly than the majority population. So the idea was, well, we can eliminate prejudice by letting the legislature make the decisions. Now, as I said, you're not eliminating discretion. What you're doing is you're moving it from one area to another. You're moving it from the bench to the legislature. So, three ideas kind of came to dominate late 20th century America. One, all crimes need punishment to be true deterrents. So the way you deter crime is you punish. And this is a very attractive idea to people. It's the idea of, why don't people commit crimes? They don't commit crimes because they're afraid, they're being deterred. Many or most offenders need to serve severe punishments because their crimes are very serious. And repeat offenders can't be fixed, and you simply need to incapacitate them. Rehabilitation begins to go out the window. Also, one of the things that was happening in conjunction with this was the movement towards the abolition of the death penalty, which I would say in America probably reached its apex in the early 70s, stopped. And we go from a moratorium on the death penalty to its reimposition. The result of this is our prison populations skyrocket. America, there's roughly 300 million Americans. That's about 5% of the world's population. Again, rough numbers, not exact. So there's roughly 6 billion people. But America has over 20% of the world's prisons population. So there are per capita 4 times as many people locked up in the United States as there is in the rest of the world. And part of this is because of determinate sentencing. Okay, discretion in sentencing. What are we interested in here? Well, what are we looking at? Well, these are kind of your sentencing guidelines, and these are both demands of the experts, you can call them that, and the general public. Okay, so one of the things that people wanted was uniformity. The same offense should get the same punishment. 2, certainty and truth in sentencing, and that's a phrase that's repeated in the North Carolina sentencing law. Convicted offenders, the victims and the public, need to know what you're actually getting. So if someone gets 5 years, that they're really going to serve 5 years. They're not going to serve 15 days and get out. Do the crime, do the time. And finally, really a rise in retribution, vengeance. We began to abandon the idea that we could rehabilitate people. And instead, we sought to punish people. Now, sentencing authority, okay, there were 3 broad places where there was sentencing authority. There was the legislature, where most of it is now. They can set the crime, penalty for the crime. There are the courts, there's with the judges where you give them indeterminate power. And then there's the administrative agency, because a lot of law is set up by administrative agencies. You know, there is violations of tax code and things like that. We really have a number of options for this sentencing authority. Legislative sentencing tends to be determinate because they have to make a general law that applies to everybody. So legislative law is very often determinative law. Judicial sentencing, since the judge is, yes, he's dealing with burglary, but he's dealing with this burglary, this unique set of circumstances, and he decides how high or how low it goes. Now, administrative sentencing, both the legislature and the courts can set certain ranges and leave it up to the administration. That gets much more murky. I'm not going to go deep into administrative law in this course, even though administrative law is arguably one of the most dominant forms of law in America today, just because it's pretty complex and we could spend the whole hour talking about it. All right, so sentencing guidelines. These really respond to the 3 demands of the public and the expert: uniformity, certainty, retribution. And retribution leading to deterrence and incapacitation. Now, it certainly leads to incapacitation. I think there's a legitimate question whether it leads to deterrence. So in sentencing guidelines, and we're going to look at there's a table in your book. I think it's the Minnesota Sentencing Guidelines. But we're going to look at North Carolina's because most of you here at Wake Tech are in the North Carolina. You're under North Carolina law, so let's look at those. And you're going to have guidelines set up by the legislature. And it's a very narrow range of penalties where before a judge could go 1 year or 4, the legislature is going to say things like, yeah, you can go between 5 years and 7 or 3 years and 4, but you can't suspend most sentences. Guidelines look about the seriousness of the crime, and they also go back and look at the past history of the offender. And if you're going to depart from those, if you're a judge, boy, you got to show a lot of reasons for it. And it's tough. So I said I was going to focus on North Carolina. In a minute, you're going to see the North Carolina sentencing chart for misdemeanors. But this is what we do. And this is how it happened. North Carolina structured sentencing comes in the late 20th century. At first, and this was in the 80s, it was set up for drunk drivers because it was seen kind of as a scandal how many people drive drunk and didn't get punished. So they said, well, let's set firm guidelines, determinative guidelines for drunk drivers and not let them get away with this. Later, it became very popular politically to say, well, we're going to expand this system to both misdemeanors, the very minor crimes, and to the felonies. So there are really 2 criteria, which will become clearer when we start to look at some charts here. One, we want to know your prior record level. We want to know your criminal history, how many crimes you committed in the past. Then the second thing we want to do is we want to focus on what crime you committed, and every felony has got a categorization. A, B, C, D, E, F, G, H, I. Every misdemeanor has a categorization. A1, 1, 2, or 3. So misdemeanors are numbers, felonies are letters. And punishment becomes very automatic. So let's make it clear. I built it confusing for you. So let's jump to the North Carolina structured sentencing chart for misdemeanors. Okay, so you can see where I said it's got numbers. So every misdemeanor in North Carolina gets a classification. Is it an A1 misdemeanor, which is the more serious ones? Some of those are crimes of violence. Is it a 1, a 2, or a 3? The least serious crime you could commit would be a Class 3 misdemeanor. And you'll notice on that chart, Class 3 misdemeanor, if you have no prior convictions, the maximum you can serve is fine only, right? 1 to 10 days. That's going to be a suspended sentence, community service. If you have 3 convictions for a very minor one, fine only. It's only after 4 convictions for misdemeanors that you actually can spend some time in jail. For most misdemeanors, if you do not have, except the A1 misdemeanors, which would be a serious assault usually, for most misdemeanors, you're going to get community service. Probably serve a little bit of time in jail awaiting trial, but that's what you're going to get. Now let's look at the structures for the felonies, because that's a little clearer. Okay. So, I'm hoping you can see this arrow here. Here is the offense class. Every offense in North Carolina is labeled A, B1, B2, C, D, E, F, G, H, I. We only have one Class A, and that's first-degree murder. But for all the others, if you look at these numbers here, these aren't ranges of days like the misdemeanor. These are ranges of months. So let's suppose you got convicted of a Class C misdemeanor. Well, we would go back and look at your prior record level. And let's suppose you were in the regular range. Okay? So I said it was C3. Presumptive range, what you would get is the judge could sentence you to 77 to 96 months. That would be your sentence. Now, there can be some leeway there so that you behave in prison, but basically that's your sentence. If he thought you were good, if he thought you had mitigated your sentence, he can bump that down to 58 to 77. If he thought you were particularly bad, he can bump it up to 96 to 120. So the difference there is between 5 and 10 years. It's a pretty big difference. All right. Mandatory minimum sentences. Mandatory minimum sentences require a judge to impose a non-discretionary minimum amount of time in prison. If we go back to this chart, you notice all these A's, right? If you commit a Class D felony, you'll notice everything, even if you have no prior offenses, it's got an A, that's active time in prison. So if you've committed a Class D felony, which would be a serious crime, you're going to serve at least 3 years in prison, 38 months. You could serve as many as 80 months in prison, which is pretty serious. Now you're looking at 6 years. So there's a big difference. Okay, let me jump forward here. Excuse me. Judges can sentence to more time, but generally not less than your mandatory minimums. Mandatory minimums are supposed to satisfy the 3 basic criminal punishments: retribution, vengeance; incapacitation, removing them from the society; and deterrence. Now, basically, this can be summed up as, you do the crime, you do the time. The biggest problem I see with this is that empirical support that this works, that having mandatory minimums keeps people from committing crimes and lowers the crime rate, there's not a lot of good evidence to support that's true. We've been studying this for going on 100 years, and even though it's an attractive idea to people that the more you punish, the lower your crime rate, it just doesn't seem to be true. But as I've said before in many of my classes, we don't operate on what's true, we operate on what we believe to be true or what we want to believe to be true. So has mandatory sentencing eliminated discretion or discrimination or lowered crime? No. Minorities, men, and young defendants all continue to be punished more harshly than other groups. An increased punishment has had no real effect on the crime rate. We started really whacking people with heavy sentences in the 70s, and crimes kept going up. We did see a decrease in crime starting in the 90s, late 80s, early 90s, but not really related to our incarceration spree. It may, in fact, having more punishment, increase recidivism, which is the likelihood you go back to prison. Okay, so let's get back to evidence in our old friend, the Constitution. There are 2 kinds of constitutional questions when we begin to look at sentencing. One, is whatever sentence being imposed cruel and unusual and is therefore banned under the 8th Amendment? And what, if any, rights the defendant enjoyed before conviction, during trial, and plea bargain, do they have afterwards? In other words, when you go from defendant to offender, what is your new bundle of rights? All right, so one of the questions about cruel and unusual punishment is proportionality. The proportionality principle states that a punishment is cruel and unusual and therefore violates the 8th Amendment if the harshness is grossly disproportionate to the gravity of the offense. Quick, silly example. If the penalty for jaywalking was death by slow torture, the courts would throw out and say, this is just grossly disproportionate. It almost always, the proportionality principle is almost always imposed in cases of murder. So we look and we say, does the death penalty, okay, should it apply in this case? And it really focuses on juveniles, offenders with mental disabilities, and some other exceptions. You don't have a lot of proportionality arguments for other crimes. There are a few cases where the Supreme Court has dealt with terms of imprisonment. Can they be that long? And they really haven't touched them too much. I think because particularly this court, as it has been composed today, is kind of, I won't say against, but kind of not interested or feels it's inappropriate to interfere in the power of the legislature. All right, let's look at a case. And this is a shoplifting case, and it's going to involve videotapes. So in 1995, and this is Lockyer, Attorney General of California versus Andrade. Leonardo Andrade, who is who's the guy's appealing here. He was convicted. He stole 5 videos from Kmart. They were valued at between $87 and $64. Now, he had committed a burglary in 1982 and a petty theft in 1990. So over the period of 15 years, or a little bit less, 13 years, he had committed a burglary, pretty serious charge, petty theft, and stole some videos, arguably shoplifting. California had a 3 strikes you're outlaw. So he, like I said, for stealing these videos, 5 in one instance and 4 in the second one, he was sentenced under the California statute to life. And he appealed and said, this is crazy. And the California Court of Appeals said, no, these 2 consecutive, which is one after another, 25 years to life prison terms are okay. Goes up to the Supreme Court of the United States, and this case was written by O'Connor, who at the time was this 2003. I guess O'Connor was still on the bench. It was joined by Rehnquist. It was still the Rehnquist Court. Scalia, Kennedy, and Thomas. They uphold it. Now the dissent said, no, this really goes too far. It didn't fit an earlier case, Ewing versus California or Sloan v. Helms, and it should be overturned because it was extraordinarily disproportionate. And that opinion was written by Souter, joined by Justice Stevens, Ginsburg, and Breyer. But the majority said you can go to jail for life for shoplifting, which goes to show that for incarceration cases, the standard is pretty high before the court's going to go in. Now, one of the areas the court does get interested in is juveniles. Juveniles seem to be a special case, and they seem to enjoy a little bit more protection. We're going to look at another case in just a second. I'm going to look at a Florida case, not a Florida man case, a Florida juvenile case. At least to some on the Supreme Court of the United States, very, very long sentences for juveniles, including for life, should be held to this higher standard. There should be some proportionality. Some justices say, nope, and it would have been Thomas and Scalia. I guess Thomas is probably the leading one now. Some justices hold that life sentences are simply not cruel and unusual punishments, and the court has no power to overturn them. So let's look at this Florida case I kind of teased you with, and this is Graham versus Florida. Came down in 2010. Not a particularly old case. Graham was 16 and he tried to rob a restaurant. He got 12 months probation. 6 months later, he got arrested for burglary while he was on probation. He was sentenced to life without parole. So he's 16 in Florida and he gets life without parole. The majority said you can't impose this on juveniles unless it's a homicide. And this was not a unanimous opinion. The majority opinion was there, but there was a concurring, and of course Thomas, Scalia, and Alito dissented. The majority said, yes, this is too much, but 4 out of the 5 justices said, no, it was okay. And I would say if the same case came up today, probably go the other way, because you've really changed the composition of the court. The court's become even more conservative. Now, what rights do you have at sentencing? Until 2000, the court took basically hands off. They said, this is up to the judge. But this changed a little bit in the year 2000, and this is going to be a case, well, we'll just jump to it. Apprendi versus New Jersey. So this established what's called a bright line rule for sentencing. Defendants have a right to a jury to determine all the facts that increase their sentences beyond the max. So juries have to decide whether there's proof beyond a reasonable doubt of those facts, and proof of facts of prior crimes don't need to go to juries. So the Supreme Court sentencing rights cases, Apprendi, which came down, that actually struck down a New Jersey statute that gave judges that power, and they said, no, you're going to turn it to the juries. It was a 5-4 decision. And there's been a few like that. There's been Blakely out of Washington. That was a 5-4. There was U.S. versus Booker. I think that was a 5-4, and I think it was Washington. I'm not positive. It might have been another one. Then there was the Rita case, which came down, and finally the Gall case that came down. All of those kind of refer to the Apprendi and the Booker case. The Booker becomes important because it really focuses on federal sentencing guidelines. All right. So here are those cases for you to take a look at. Harris versus the U.S. 2002. Judges can raise the mandatory minimum, but not beyond the statutory maximum. Judges can't impose more time based on facts not found by proof beyond a reasonable doubt. Booker reaffirms Blakely, and Rita, sentences within recommended ranges can be presumed to be reasonable. Well, let's look at our next case that's outlined in your text, and this one is, I think it's an opinion by Stevens, 2007. What happened here is Gall, in the year 2000, sold some drugs. I think he was in college, if I'm not mistaken. And he netted about $30,000. But after about 6 months in this, he withdrew from the conspiracy. And in 2002, he admitted it in an interview with the feds, which is obviously not the brightest thing he could have done. He was arrested in 2004. This is 4 years after having done this. The federals, the prosecutors, said, we want 3 years in prison for this, even though he had admitted to the crime, cooperated. The judge said, we're going to give him probation. Now at this point, the sentence has already occurred. You're not going to overturn the conviction, but the government can appeal the sentence, which is what they did. The majority in this case, the Gall majority, which was Stevens, and it tended to be, said the sentence was reasonable. The dissent argued, nope, you should have followed the guidelines. That was primarily Alito. Alito's very pro-prosecutor and very pro-guideline. All right, let's talk about death penalty. SCOTUS has made it clear that the death penalty is not cruel and unusual. I think whatever progress was, if you call it that, progress was being made toward abolishing the death penalty in the United States, died in 1973. It died as the Supreme Court became more conservative. I think at some point the court was leaning towards abolishing the death penalty. The court has said over and over again that the death penalty is not cruel and unusual. However, they do recognize that it's different, and that death sentences are different too. Death is different. The sentencing process must allow the judge and the jury to look at aggravating and mitigating. So if you had a mandatory death sentence upon conviction, that's going to get tossed. The law should provide for a review procedure to also ensure there's no discriminatory actions going on. Now, statistics indicate, and this is part of the problem, you can say, well, we've gotten rid of overt discrimination. Well, maybe. I think the problem with that argument is going to be you claim to have gotten rid of it, but we're still disproportionately punishing men and racial minorities. And that's a significant issue. Statistics indicate that this seems to be pretty unfair. Now, the court has conceded that these numbers may prove that race affects the death penalty in general, but you can't prove it specifically, which is kind of a weird argument. I think it's disingenuous, but nonetheless, the court embraces it. So let's look at some aggravating and mitigating circumstances in death penalty cases. So what are some things that would likely to get death penalty? Prior record of violent felony, felony murder. That means you committed the murder while in the commission of another felony, like robbing a bank or kidnapping. You murder more than one person. You murder a police officer. You torture or heinously kill someone. You kill to avoid arrest, or you kill while you're already in custody. All those can be aggravating enough that can be considered by a jury in the bifurcated trial to sentence you to death. Mitigating: no prior criminal record, mental or emotional disturbance, not going to the level of insanity, minor participation, so it's a murder felony but you were just driving the car, or you were a youth at the time, although you can't execute someone who's under 18 in the United States. Okay, appeals and habeas corpus. Offenders do not have a constitutional right to appeal their convictions, but, and it's a big but, all states, including the federal government, says you have a statutory right. So it may not be in the Constitution, but we are giving you the right in statute, in law. So this statutory right to appeal applies only to the intermediate appellate courts. So in North Carolina, if you you get convicted in Superior Court for a felony, you've got a right to appeal automatically, basically. We'll put murder aside because it can be special, to the North Carolina Court of Appeals. And they're going to have to hear your appeal. But after that, you don't have an automatic right to appeal to the Supreme Court of North Carolina. And then, of course, the question is, can you get over to the federal side, which is usually a habeas corpus? It also limits discretionary appeals through something called writs of certiorari. And I know it doesn't look like that's how it's pronounced, but again, we're dealing with that kind of bad Latin that's shot through the law. A writ of certiorari is an order from an upper court to a lower court to turn over its criminal records. And if you have a writ of certiorari, it really means, if it's granted, it means they're going to hear the appeal. It's a voluntary appeal. So what's the scope of when and we haven't gotten to habeas corpus yet, but what's the scope of appeal? Three principal doctrines look at how big the appeal can be. One, is it moot? Moot means, well, you're appealing a conviction for 2 years, but you already served it. You're appealing for a fine of $1,000, but you already paid it. Now, unless it's going to have more consequences down the road, we're going to say that you can't sustain your appeal. Here's a big one, and most people don't realize this, and that's why you better have an attorney when you go to trial. You generally, if you're going to say they ruled wrong, because remember, you're appealing an error of law, error, E-R-R-O-R, error of law. Let's suppose you want to claim that the confession that was let in was coerced, it was therefore involuntary, it therefore violated both due process and the self-incrimination clause. Okay, so you have better have made an objection at trial. If you didn't object to that, or more properly, your attorney object to it, it's really deemed to have waived it. If you didn't raise an objection at trial, you can't do it now on appeal. Otherwise, attorneys would just wait and would never object to anything, even if it was wrong, wait for an appeal, and then get a whole new trial. Finally, we've got plain error. An error that was made that could have led to a miscarriage of justice. Basically, you do have to show that your error mattered and that it was serious. All right, so habeas corpus or collateral attacks. You can indirectly attack a judgment in a new non-criminal lawsuit.
what you do in a habeas corpus attack is, let's suppose you're being held in central prison or the jail in Laramie, Wyoming, I don't care. You sue the warden of central prison, or the jailer, it would be the sheriff probably, of the jail in Laramie, Wyoming, and claim you were being unlawfully detained for this, this, and this reasons. That's a collateral attack. It's not a direct attack. You're not appealing your conviction, but you're indirectly appealing it. Collateral means kind of around the side. So there are three kinds of collateral attacks. State collateral review for defendants who are convicted in state courts, federal court collateral review for defendants who are convicted in federal courts, and then federal habeas corpus reviews for defendants convicted in state court. This used to be how a lot of cases got up to the Supreme Court. But lately, it's kind of been under attack. Now, the Habeas Corpus Act of 1867 created basically the right to appeal to protect the newly freed slaves in southern courts. Because what used to happen was you'd get people convicted in state courts in the South, these freemen, these newly freed slaves, and there was no way that they could say, hey, look, this is completely wrong. I was convicted under state law. I need to get to federal court and I need to show you. And this kept expanding until it got really big, and there was a lot of these habeas corpus appeals. And then the conservative reaction set in, and it was kind of attacked, and it began to be scaled back. Particularly under Justice Berger, who comes after Warren, but really under Rehnquist and Roberts, we have fewer and fewer of these habeas corpus petitions getting to the federal judiciary. And it really was because the court said, well, we want sentences to be final. We want things to be settled. And we don't want all these collateral attacks. One of the pieces of legislation that's important here, and then we'll look at least one more case before we close out the chapter, is the Anti-Terrorism and Effective Death Penalty Act of 1976. And this really first and foremost, put a 1-year statute of limitations on to file appeals, which was pretty big. It encouraged but didn't mandate counsel for indigent defendants, and it really required lower courts to see if this was just repetitive. But what it did was put an almost total ban on reconsidering legal and factual issues that were already decided. The end result of this, even though it's got a nice sounding name, who isn't against terrorism? And I guess who doesn't want an effective death penalty, since most Americans believe in it, is it began to really limit habeas corpus. Okay, now we have the last case in this chapter. And this is a Ginsburg case, Ruth Bader. So this is McQuiggins, great name, versus Perkins. Came down in 2013. He was convicted in 1993. He was at basically a party in Flint, Michigan, and he was there with a friend of his and an acquaintance, and they left the party together, and one of the people, including Perkins' friend, was found dead. So he gets arrested and he gets convicted. He gets life without parole. His final sentencing is 1997. Between 1997 and 2003, he produced at least 3 affidavits of innocence, claiming, look, I'm actually innocent of this crime, they made a mistake. There was a rule. The court ruled that these claims were subject to a 1-year rule, which said if you don't bring up a claim that you're actually innocent, which is a rare thing to appeal upon, it's very much a Hail Mary offense. If you don't do it within 1 year, you can't bring it up. You can't claim you're innocent. It seems strange. Most people aren't lawyers think, well, isn't that what you appeal on all the time? And that's not true. Most appeals are not based on facts. You're not trying to claim that something is wrong, false, or true, if you're trying to claim the opposite of it. You're trying to claim that a law was violated. So the majority said, again, this was under the 1996 Anti-Terrorism and Effective Death Penalty. I think I put 76 on that, and it really is 96. I'll have to go back and change it in the notes. Under this, state prisoners, these actual claims are not limited to 1-year rule. And the dissent, and if I at this point, if I said, well, who would write this dissent, most of you should say, well, super conservative, it's got to be Scalia, maybe Thomas. You'd be right, it's Scalia. Says the 1-year rule is constitutional, even if you're innocent. So what Scalia is saying that is, even if you're innocent, you've got a year to protest, and if you don't have a year, if you don't protest in a year, you stay in prison the rest of your life. Your life without parole is okay. That was not upheld. Right now, the majority is not so. Okay. We've only got one more chapter left, and this is going to focus on things that are a little bit of outside the scope of the traditional course. We're going to start looking at criminal procedures in times of crisis. So we'll look at some of these terrorism things. We'll look at the National Security Agency. We'll look at counterterrorism. We'll look at illegal immigrants. All these are very hot topics currently, but we'll move on to our last chapter whenever you're ready. Have a good afternoon, good morning, or good evening, and I will see you for the last chapter whenever you're ready.